I've uploaded a dedicated video on homesteading and why property begins with self-ownership and first appropriation. I've also done a video on crime and restitution where I explained why the criminal aspect of a just legal system should be predicated on the rights of the victim. So in this video, I'm not going to re-explain why we talk more about Murray Rothbard than John Locke, or why we talk about restitution instead of deterrence or rehabilitation. I'll leave the links to those theory videos in the description. This video is about a practical question that keeps coming up. How would courts and arbitration be funded in a free society? As Rothbard says in Power and Market, we cannot blueprint the exact institutional conditions of any market in advance, but we can still explain how a freely competitive system of private guards and judicial services might operate in order to illustrate how markets work. The bottom line is that there are two basic funding sources in a free market legal system. First, demand from consumers who need arbitration or protection, and second, restitution from aggressors who are convicted. So the prototypical case would be a thief who has to return what he stole and also work off the costs of catching him and getting a conviction. And the basic case for an arbitrator is someone who is paid by two parties to make a binding ruling on their dispute. Everything is really some permutation of these two sources. Rothbard suggests legal services would likely be sold by advanced subscription with regular premiums, and that firms would compete by earning reputations for efficiency and honesty. He also points out that insurance companies would have an obvious incentive to provide or fund protection and legal services because reduced crime reduces their payouts. Courts might also be hired by protection agencies, or firms might be vertically integrated, providing both protective and judicial services. So you might see a blending of these industries in some places. Only the market can decide which methods are most appropriate. In a tax-funded system, victims have to pay for the apprehension and incarceration of criminals, instead of criminals being forced to pay restitution to the victims. The courts are funded regardless of whether they are good or bad. You pay whether you use them or not, and whether they protect you or fail you. But in a market, courts have to compete to make their services quick, reliable, and trustworthy. In addition to subscriptions, you could also have arrangements like legal insurance or simple case-by-case fees. And importantly, there's also arbitration clauses, which deserve special attention. People like Brian Kaplan have suggested that if contracts commonly named arbitrators in case of conflict, that alone would go a long way towards privatizing the legal system. If a court is fair, it is more likely to be chosen by people when they form contracts and need to designate a court or arbitrator for dispute resolution. A court that is seen as favoring a particular demographic, or favoring the rich, or selling verdicts will be avoided. The product of a court is not marble columns, robes, flags, and Latin phrases. The product of a court is trusted judgment. If people do not trust your judgment, you will not survive the market. There's also the concern of armed groups simply foregoing the legal process altogether. But as Rothbard argues in The Ethics of Liberty, it would be economically absurd to expect protective agencies to physically battle each other, because warfare would alienate consumers and be enormously expensive. The market incentive is for agencies to agree in advance on private appeals courts or arbitrators to resolve disputes peacefully. One final issue is cutoff. Every legal system needs some sort of socially agreed upon cutoff point, a point at which judicial procedure stops and enforcement against the liable party begins. The current system arbitrarily makes the state's highest court the cutoff point. A libertarian legal code would instead treat the decision of any two courts as binding. That is, after a second court, effectively acting as the court of appeal, has rendered its decision, that can then be taken by society as binding and final. It's as simple as that. It's important to remember that law has existed in many forms, and even in the common law tradition we're familiar with in the West, contract and tort law preceded legislation. So this isn't a new idea, it's just returning to an older tradition of restitution-based law. The state did not invent law. It monopolized law and then made everyone pay for the monopoly, especially the victims.